Lordship.
Yes.
I would like to mention item number
19.
19. Yes, the petitioner, the counsel of the petitioner, Mr. Binder Picha, is out of station due to some personal problem. So 2 weeks time may be given. 2 weeks time.
Your name, please?
Karmo Chotan, K Chotan.
MS Learning Council. Appearing on behalf of Mr.
Binder Picha.
B. Picha, Council for the petitioner. Then the council for the appellant, applicant's appellant. Press for listing the matter after
2 weeks.
2 weeks. On the ground that the leading counsel, Mr. B. Picha, is indisposed today.
Okay.
Press allowed list this matter after 2 weeks.
Yeah, Lordship.
Yes.
Lordship, I beg to mention item number 9.
9.
Yes, Lordship. Lordship, the conducting council is on leave.
On the prayer of Mr. Learned Counsel for the petition, list this matter after 2 weeks.
Okay. Oblige.
Yes, PP, who is appearing? Item 1.
Yes, Your Lord. I'm appearing, Your Lordship.
None appears for the petition. On court, list after 3 weeks.
Your Lordship, if Your Lordship may excuse me for just a moment, Your Lordship, I need to bring the files, Your Lordship.
Item 2, I'm appearing.
Item number 2.
Yes, sir.
1 or 2?
2.
2. Yes.
Lordship, this is a joint petition also under file 482 of this CRPC. This is a case regarding Sagali PS, Lordship, in connection with 379-511 of IPC also.
Will issue notice today?
And there is an interim also, Lordship. My interim. It's pending before the CGM UP also.
What's the offense?
379 and 511. 379 is compoundable regarding 511 also. If may kindly go to the FIR also. Page number 27 also.
Yes.
May I read also? 27.
Yes.
This is the type copy also. May I read also? To the officer in charge, police station Sagali. It is to inform you that I caught 2 persons red-handed around 8 a.m. 23/3/2022 at BSNL BTS mobile tower at MEP while they were attempting to steal BTS material. A motorcycle bearing registration so-and-so was at the spot, which they bought along with them. First, I observed them as they were dismantling the feeder cables, climbing on the tower. When I approached them and asked them about what they are doing, they said they were being sent by the BSNL office. While whole matter was taking place, one more person came to the spot. While was being called up by red-handed and caught 2 persons. Therefore, I request you. This is basically a FIR registered by the one person who is the caretaker of the tower, Your Lordship. The BSNL tower. Now they have mutually settled this cases, Your Lordship. I have annexed the mutual deed of agreement, Your Lordship.
What is the stage of case?
In the CGM, the charge has been framed. The framing of charges.
CC.
Yes, for CC, which has been
Charge has been framed.
not
Have
yet.
been framed.
Not yet. Your Lordship.
Charges have been framed.
Not yet, sir.
Please your notice.
Yes, Your Lordship, on the last occasion, why this matter came again, Your Lordship may see that though the agreement was made by the Site caretaker, your lordship.
Huh?
The site caretaker, your lordship, who is the informant, your lordship. However, your lordship will see the crime was against dismantling of feeder cables, which is of government property, your lordship.
Hmm.
So any agreement,
Hmm.
not by the property owner, by the accused, would not be considered.
Will issue notice, but then you take your own thing.
Your worship,
Whatever it wants to
my
do.
prayer is my interim may be allowed, your worship.
No,
Huh?
My interim. Also,
No, there is no agreement
on the last day,
between the affected person,
because this complainant, he was the caretaker of that tower, your worship.
but then he's not the owner of that.
Not the owner, but
You have a compromise with the agreement with, discuss with your, the owner and the head of the thing. All right,
okay, yes, your worship.
heard Mr. So-and-so learned counsel for the petition. Petitioners, huh?
Yes, your worship.
Three petitioners.
Three
Four.
petitioner,
Petitioners.
including the one is the
Next
informant.
By this is an application under section 482 of CRPC, 1974, seeking quashment of the criminal proceedings of GR case number 239 of 2022 under section 379 51134 IPC, pending before the London Chief Judicial Magistrate, Capital Complex, UPIA. Chief Judicial Magistrate, UPIA, on the basis of the settlement entered into between the informant and the accused persons. Issue notice returnable in 4 weeks. MST Gini Learned additional PT appears on behalf of the state. Call for the LCR,
LCR, your lordship.
TCR.
Scanned copy of LCR, TCR, your lordship.
Call for the scanned copy of the TCR. Pending production of the TCR. The criminal proceedings in GR case number 239/2022, pending before the Chief Judicial Magistrate, still remains suspended.
Replay.
No problem, sir.
Five zero four three four, same order. Heard Mr. So-and-so, learned counsel for the petition. Petitioners, how many petitioners?
Three petitioners. Petitioner number 1 and 2 are the alleged accused, and number 3 is a victim. So it's a joint petition. And all the sections are actually compoundable.
Huh?
All the sections are compoundable section,
Then,
but the trial has not commenced
huh?
in the lower court.
What is the stage?
It's just
Charge sheet has been
started,
filed.
just,
Charge sheet has been filed.
yes. But it's not commenced.
When the next date fixed?
There is no date fixed. Still, it's not put up
When was the
before.
last date fixed?
Lordship,
When
it's
last
not
was
put
it?
up yet for
Huh?
trial. It's not put up before the honorable court.
Then in the heard Mr. So-and-so learned counsel for the petitioner. Next para, the application so-and-so, for seeking quashment of FIR as well as the charge sheet.
Yes.
Should we say charge sheet? Madam,
Yes, your lordship.
charge sheet,
Charge sheet,
washing of charge sheet,
charge sheet, your lordship.
seeking washment of charge sheet. Number
GR
51 of 2021, dated
GR case number
26, 11/2021. In GR case,
187 of 2021.
87 of.
Your lordship, just a small submission, your lordship. If the matters are all compoundable, your
Yeah.
lordship, this court does not have, it
Mm.
ought not to have been filed before the honorable court, your lordship.
Hmm.
Only before the court, which can compound the matters. And the 482, if
Correct,
only the
correct.
matters are not compounded.
Lordship,
This is correct,
it has
that is
been
that.
more than 3 years.
No, it doesn't, that's not the matter, that's not the question.
Lordship,
If it's all are commendable, we'll list it on 27, will you think about it, all right? On the prayer of,
Uh,
just delete all this thing.
20,
If it is compoundable, do we agree?
yes, it's compoundable, but 506
No, is that because there's a delay in fixing the, taking up the matter, there's no ground for quashment,
it's,
right?
it's delay
Right.
for 3 years, Lordship. So
Have you seen some other cases?
on delay, it's,
Delay is not a ground for quashing the thing, if it is compoundable.
because here one of the alleged accused,
Sorry, sir. On the prayer of, on the prayer of Mr. So-and-so, learned counsel for the petitioner, this matter on 27,
Lordship 20, yes, 27.
27. On the,
Oh, Lordship, sorry,
In view-
28 will do, Lordship.
28.
Yes, 28.
in view of
please.
the fact that the, all the sections are compoundable, which the criminal petition may not lie. This stuff. MS so-and-so, learned additional people present, huh? 28, you think about it, have some research, go through the law, right? Your only ground is delay. 3 years delay. No, that cannot.
Because this,
You find out.
one of
It's
this,
okay. Thank you.
Deeply.
highly obliged.
May I please, my lord, can
Yes.
it be passed over for some time? Conducting council euphorious in traffic.
Possible. Issue notice.
But the other side is
It's okay. We'll issue notice. We'll record someone's name.
Yes, ma'am.
Promotion.
Yes, ma'am.
As-
Regularization
as,
of my official
Uh,
information.
with retrospective effect.
Yes, madam. My lord, I have,
And Mr. H. Lampu, learned counsel for the petition. By filing this application, petitioner prays for a direction to the respondent authority to convene a review DPC for reconsideration of the case of the petitioner for regulation to the post of assistant engineer within bracket electrical with a retrospective effect. In other words, from the date when he became eligible
my lord.
and allowed to hold the charge of allowed to hold the charge or allowed to function as
Officiating assistant. engineer.
officiating assistant engineer. Elastic issue notice returnable in 4 weeks. You are
I'm for appearing on behalf of El Perme.
huh?
El Perme.
El Perme. Mr. So-and-so appears on behalf of El Perme, learned standing counsel to Power Department. Huh?
Power Department.
How many respondents?
Dear my lord, I, state is also dear my lord, chief secretary.
None appears for the state.
1, 2, 1, 2, 3, 4, 4. He will be appear for 2, 3, 4.
2, 3, 4. Chairperson also?
Chairperson or DPC?
Chairperson. The
No, my
The-
lord.
what about
I'm
the-
sorry, my lord. Chairperson 1 and 4 will be appear by, will be represented by the government branch. 1 and 4.
Right.
So chairperson is chief.
Are you appearing? Mr. I. Ramlanan, additional senior governor, appears on behalf of, appears and accepted on behalf, not accepted notice, accepts notice on behalf of respondent number 1 and 4. Then Mr. So-and-so, learned counsel appearing on behalf of Mr. L. Perme, learned standing counsel for respondent number 2 and 3. Says the learned counsel for the state respondents enters appearance on behalf of enters appearance, no formal notice need be served. However, extra copies be furnished to the learned counsel to the purchase. List after 4 weeks.
My lord, I have an interim prayer.
What is the interim prayer?
My lord have produced the record, my lord. As per my lord, the claim of the petitioner, my lord.
It's okay.
As per rule, my lord, he was already eligible for my lord promotion in 2004. Thereafter, my lord, The next promotion is executive engineer, my lord. And he is eligible to be
No,
promoted.
unless
to
you have been regularized from the date of the DPC.
Yes, my lord.
Unless that is interfered with, how can there be an?
Yes, my lord, that will be, my lord, I understand, my lord, that will be the consequence of this, my lord, my first peer, my lord.
Huh?
That will be, my lord, follow-up peer of my first peer. First peer is regarding my
No,
retrospective.
if your agent as it stands today, as
Yes,
it
ma'am.
stands on today, as
Yes,
on
ma'am.
today, you are not eligible for consideration.
My lord,
If we take the, I mean, from date of regulation as an assistant engineer,
my lord.
you have not completed
Yes,
the
ma'am.
required qualifications. So,
As per the DPC, my lord.
Huh?
As per DPC, I'm not.
yes,
no.
yes. So your prayer is basically to for retrospective regularization.
Yes, my lord. First prayer, my
Regulation
lord.
with counting the first service.
Yes, my lord. And second prayer is, my lord, to direct the respondent authority to consider my promotion for executive engineer, my lord. Since
Huh?
I have, my promotion was also already due on 2019 as per rules, my lord. But because of this, my lord, not giving me retrospective my lord, promotion, I have my
We'll just say,
right for consideration.
we'll just say, pendency of the birth shall not be a bar. Pendency of this representation shall not be a bar to consider the case of the petitioner in accordance with law.
But my lord, sir, in my humble submission, man, there is, my lord, more than 3 posts are, my lord, polling vacant.
So in that case, we'll stay your regulation order. You
No,
remain as a officiating.
No, my lord. Actually, my lord, the 3 posts of, my lord,
It's okay,
executive engineer
unless,
is,
are you, as on today, when you count the date of regulation from
No.
the date of DPC,
my lord.
are you eligible? No.
From DPC, I'm not eligible, my lord. But
Next,
my lord,
we'll see next time.
but my lord, there are, my lord, posts
First,
are dying
you have
vacant.
to establish that you may have a case for retrospective regulation that we'll consider. That's your case. Unless we interfere, there cannot be any interview.
My lord,
All right.
oblige.
Am I correct?
Yes, my lord.
This after 4 weeks.
Kindly pass over this matter for some time because the learned AAG is appearing in this matter.
So,
Items. Learned AAG is appearing.
so what is to be done?
But I believe he's on Lexington port number 1.
We'll see after some time.
Yes.
May I please? Hello, this is joint application file under 482 for passing of the FIR as well as the charges were already submitted.
Okay. What is this stage?
Stage charge is yet to be framed. It has been endorsed to JMFC.
What is the offense?
Offense is charge sheet is submitted under section 354A B 447 506 323 354B is non-compatible. Rest they are compatible.
What is this additional affidavit you have filed?
Petitioner has to file affidavit stating that she has no objection. She has settled the matter. They have settled the matter outside.
Since this was a joint petition, your lordship, and the affidavit was filed only by the petitioner number 1, and therefore there was a direction that an affidavit has to be on
Yes.
behalf of respondent number, petitioner number 2.
So, what is to be done?
Your lordship, otherwise, only out 354B is there, your lordship, that is outrighting the modesty with sexual intent, your lordship. I don't have any objection for this, your lordship.
No time will dispose of.
The
All of
The short matter, but Private respondent is making appearance today in this matter.
Because he's, as I mentioned, Binder Pichai is out of station. So he has sought for 2 weeks'
I'm filing
time.
my power.
Hmm.
I'm filing my power.
You are for respondent.
Private petitioner.
Then you-
Binder Pichai is for respondent number 1 to 5.
Ah,
Respondent number 1 to 5.
It wasn't, this was taken to appeal.
It was taken to appeal
And
and
remanded back.
it was remanded back to the single bench for expeditious hearing.
Hmm. So you are praying for
2
some
weeks' time, Your
2 weeks'
Lordship.
time.
That nomination parts, lot of advocates are involved. So,
MS,
K. Choton.
Learned Council. You are in the case.
No, I'm just appearing for Binder Pichai.
Huh?
I'm just appearing for Binder Pichai on his behalf.
Is it?
Yes,
This
Your
is
Lordship.
item,
Item number 8.
yes, item 8,
item 8,
second.
which is, you are for respondent.
Respondent number 1 to
So
5.
who is for petitioner?
I am for the petitioner.
Huh?
I am for the petitioner.
Okay, you are for the petitioner.
Yes.
My lord, may I examine, my lord?
I am filing my power today.
Okay.
I am interim, my lord, appearance on behalf of respondent number 6 today, my lord.
Hmm.
Just now I have received a copy, my lord. I will also press some 3 time, my lord, to file appearance.
Respondent 6.
6, my lord.
Private
Private respondent, my
respondent. Mr. Titi Tara, Learned Council submits that
Second. For this.
he is entering,
Second.
he would be filing his power
Yes.
on behalf of the petitioner today, for which he seeks for 2 weeks' time to list the matter. 2 weeks' time for listing the matter. Mr. El Perme enters appearance on behalf of
Respondent number 6, my lord. I have filed my authority, my lord. Just morning in the morning.
and
For the private.
seeks for 2 weeks' time to file affidavit in opposition to the MS so Learned Council appearing on behalf of Mr. B. Pichai, Learned Council for the respondent number
1 to 5.
1 to 5. Also 6 for listing the matter after, phrase for listing the matter after 2 weeks. Leave the above.
4th April.
The matter be listed after 2 weeks.
4th April.
We need to fix the date.
Requesting.
List the matter after 2 weeks on 4th of 04/04/2020.
Great.
Oh, yes.
In connection with 468 also. My pre-arrest bail was granted on 9th of January, and I appear on 10th. Multiple times I have appeared. Also, if you also may kindly see the FIR also in the page number 11. This is the type copy also.
Yes.
May I read? I would like to inform you that 9 numbers of sanctioned orders amounting of 85 lakhs were prepared fraudulently under signature and undersigned by some unknown person. The sanction was prepared, were submitted to the Chief Engineer PWD Western Zone for further process and passing of the bills. Copy of 9 sanction orders along with the fund allocation copy from the Planning Department under the fund for the year 2023 to 2004 is enclosed. Herewith a register request inquiry may be pleased to conduct. This is the FIR also. In the FIR also, my name is nowhere reflected also. And there was a clear instruction by this honorable court to appear before the IO.
Hmm.
In multiple times I have appeared. Before filing of this AB also, I have appeared. I have mentioned in my petition also. I have, best of my knowledge, I have disclosed everything also.
Additional affidavit, additional affidavit.
So my prayer is that in this case, my bail maybe make absolute also.
I'll just highlight the entire, your lordship will see this matter was first came up in the month of January, your lordship.
Hmm.
And CD was called for it.
Hmm.
Your lordship will see from before this honorable court, your lordship.
Hmm.
Thereafter, on many occasions,
Hmm.
on 6 occasions, this honorable court was pleased to allow him interim protection, but however, directing him to cooperate with the investigation, your lordship.
Hmm.
Meanwhile, he appeared before the IO, your lordship.
Hmm.
The IO, your lordship will see the statement of the accused, your lordship. 9th section, he clearly says that he has revealed the name, your lordship.
Hmm.
Subsequently, he also says that he got the sanction order outside the secretariat building. He does not disclose, your lordship. And this was brought to the notice of this honorable the names. And therefore, on the last occasion, on 23rd February, this honorable court has clearly made an opinion that you cooperate properly, just giving a statement would not suffice, your lordship. You give the names, and then your bail would be looked into, your lordship.
Yes.
Your worship, may kindly see the whole scenario, worship. I'm appearing from.
Forget about the whole scenario. We'll come to that later.
Yes,
You
sir.
just see how this court has proceeded.
Yes, worship.
You have given multiple times
Yes,
to cooperate. And then finally on 23rd,
yes, worship.
you have taken time to take further steps.
Yes, worship.
What is the further steps?
I
you
have
taken?
instructed that client to appear before the.
Forget about client. It's you and the client here today.
Your lordship will also see the order dated 4/3/24, your lordship.
Hmm.
Specific dates were given, your lordship. He did not appear.
Whatever, this is up to date. case
Not up to date, your lordship. Because up to date CD was not called for. And
List it on 27.
27.
You do whatever you want to do. You take care, I mean, you take note of the order dated 4/3/2024.
Yes, sir. But in this case,
And
I have-
thereafter,
yes,
on
sir.
14,
Yes, sir.
on the submission of the additional PP,
Yes, sir.
that there is no up-to-date case diary, so it was adjourned.
But in this case, I have disclosed. Whatever I know, I have disclosed before the IO.
No, whatever you want to do it.
Yes, sir.
We'll fix it on 27.
Wait.
And it's up-to-date case diary.
This is not an up-to-date case.
You
diary,
get the
your lordship.
up-to-date
I'll
case
get an
diary.
up-to-date.
Till then, my.
Only what you have to do is,
Yes, sir.
you have to cooperate.
Yes, sir.
Just simply that I have received it. You have received it while it was totally dark. Did you not recognize the person? These are all fraud. You take note of the 4/3/2020. 27 will pass appropriate orders.
There is an
Your
interim.
bail may be cancelled.
There is an interim also.
Hmm? Last two, okay. 14/3 it was continued.
Sir.
On the prayer of Mr.
Bitaba.
with our learned counsel for the applicant. List this matter on 27/03/2024. So as to enable him to take appropriate steps as directed by this court. Mr. The learned counsel for the petitioner shall also take note of the order dated 4/0/2024 passed by this court in the matter. The learned MST, the learned additional PP is directed to submit the,
Update.
please produce the up-to-date case diagram.
Much obliged.
It-
May please.
Yes.
Nasik, 439 bail application, my lord. 439 bail application,
Yes.
my lord. The case has been registered under section 20C and 15 or 25 of the NDPS, my lord. But
Why have you not appeared on last two consecutive dates?
my lord, only one date I could not reach on time, my lord.
Huh?
My lord, only one last date was, it was fixed on 13, my lord.
Ah,
13, my lord.
why?
I could not reach on time, it has only been taken and left on.
What's the offense?
But the section 20C and 25 of the NDPS, my lord. Lordship, this is the second bail application, my lord. Earlier it was rejected by this honorable court on 5th January 2023. So as on today, the case has been behind for the last 160 days, man. As on today, my lord.
Mandatory period over.
Already 20 days left.
Wait for 20 days in the case.
My lord, my lord, my lord. I'll submit your respect.
Heard by such so and so learned counsel for the petition. List this matter after 2 weeks, 3 weeks.
My lord, my lord.
2 weeks.
My lord, it'll be too longer, my lord. Can it be on the
Let the
next
20
week?
days, otherwise it will be rejected. What is the new
My
ground?
lord, my lord, my lord.
The mandatory period has not been over. Rather, I'm exposing your cause only.
Yes, my lord, my lord.
Huh?
My lord. It is
Even if it's 2 weeks,
yes, my lord.
if it is not, if the mandatory period is not completed,
Yes, my lord.
what is the new ground?
New ground will have some law points regarding admissibility of disclosure statement. As a lawsuit was last occasion, it was rejected on the ground of disclosure statement of the accused. The 4 accused person, my lord.
Okay, so
So,
that cannot be taken.
Into
You basically challenge that order.
yes, my lord.
So you go to Supreme Court,
No, no, my
not
lord.
before this court. Huh?
Can it be on earlier next week, my lord? Is it possible?
Next week will not be,
Okay,
will not get it.
my lord. Commercial quantity.
If you are trying to say that the grounds of rejection
Yes, my lord.
in the earlier round and the earlier bail application
Yes, my lord.
is not is based on erroneous,
Yes,
I mean, interpretation of the law,
yes, my lord.
then you have to go to Supreme Court.
Yes, my lord, I know.
So that will be unnecessary here. You will not withdraw.
No, no, no. That one is my lord.
Mr.
Yes, my lord. Yes,
Mr. Sanjeev
yes,
Gogoi.
yes, yes.
S. Gogoi, learned
Yes,
counsel for the petitioner. Applicant submits that the present bail application has been filed. Challenging the questioning the grounds on which the bail application was rejected by this court. Mr. Having considered the submissions, this court is of the view that if that is the ground for filing this application, it is the bail, present bail application is not maintainable at all. Mr. However, since the petition, counsel for the petitioner request for listing the matter after 2 weeks, considering that the present application relates to grant of bail, release of the accused on bail, prayer of the learned counsel for the petitioner. Applicant is granted. MSL Hagelan additional copy present. Have you understood what I have said?
Yes, my lord.
If there is the ground that earlier rejection of your bail application is on erroneous finding,
No, my lord.
you'll have to go to Supreme Court. I
Yes,
have
sir.
recorded that.
Yes.
I have recorded, you said, earlier this court has rejected the bail application of the applicant accused on the ground on misinterpretation of the law with regards to disclosure,
Yes, yes.
right? That is what you have said.
Yes, sir. One, in other.
So that's why I have recorded.
Yes,
You-
my
you
lord.
just-
Other grounds also, my lord.
So I said prior facie, I found it's not maintainable.
Mm.
However, for your request, we're
Yes,
adjourning it. It will create a problem. That is your submission, correct?
No, my lord. Along with, apart from that, other submissions also, I have also other submissions, that there is no any FSL report, a chemical examiner report regarding whether the seed contraband was ganja or not, my lord. It was not in the case diary, my lord.
But I will see. I have recorded your submission.
Yes, my lord.
If that is the case, it's not maintainable. You have to approach the higher forum.
My lord. Matter will fixed on.
Huh?
Other grounds also, my lord.
See, on your submission, I have seconded your submission. If that is the submission, according to this court, it's not maintainable.
Regarding FSL report also, they are.
Think about it.
Yes, sir. There is no any FSL report.
I have not opened your brief on your submission. I have recorded it. It's okay.
My lord, okay, well, privilege, my lord.
My lord, 12 to 15 are similar.
Ah.
So kindly 13 may be taken up, my lord. My lord, these are those allegations regarding, my lord, appointments in the education department. Allegations against the accused persons are that they are also staffs. The allegations are that we have also benefiting from the 13. Benefited by the action of the director and the deputy director of school education. My only submission now is that we were arrested on 9th of February. The SRC did not even seek their custody. We were directly sent to the judicial custody. We have been cooperating all along. FIR was filed long back, my lord. What is the purpose of now keeping us in custody, my lord? More than 40 days now. That is my whole submission, my lord. Otherwise, the whole laws your Rosalie is aware of. Bigger fees are still out, including 2 persons who were named by the approver. They are not being caught. There was a remark by this honorable court also, in spite of that, my lord, rejection by the NSCP tribunal, these people are not being caught. They have been named by the approver, but we are there. 41 days now, my lord. That is my only humble submission. They say we have our relatives were also appointed. Very well, my lord. Let the charge sheet be filed. If anything is there, we will be convicted, my lord. Now, what is the point, my lord, keeping us, my lord? You have been cooperating. In any case, not for a single day, my lord, they sought our custody. First day itself, judicial review.
My lord, CD is there, my lord. My lord, it pertains to Changlang district, my lord. The illegal appointment of PGT, PGT, and MTS, my lord. In total, there are 78 illegal appointments. As far as these petitioners are concerned, my lord, their statement has been taken, my lord, and they are in custody. They've been cooperating, my lord. They're cooperating, my lord. Their statement has been taken.
Even before arrest also, we have.
And they have revealed, my lord, that all, since they're working under the DDSC, my lord, they took that advantage, my lord. And they have requested a DDSC and they have appointed their sons and daughters. And some in TGT and some in.
All are now terminated.
They are terminated, yes, obviously. And they have accepted that they have given bribe of around some 15, some 12, it varies, my lord, from but 10 to 15 lakhs.
No, these applicants are the officers, officials of.
Oh,
the-
yes,
UDC,
UDC, LDC.
KCR, LDCs, my lord. They were preparing.
They were offered, my lord, by the DDSC, just like that, man.
So all statements recorded.
Even before.
You have not sought for any custody of these people.
No, no,
No, my lord.
that is there in the.
And according to you, there is no.
They have admitted they've even admitted how much money they have given.
Huh?
They've even admitted how much money they have given and whom they have.
But then now issue is whether their custodial interrogation.
My lord
required.
will kindly see page 37, my lord. On the first day itself, they did not seek for our custody, my lord.
37.
37. Second paragraph. By
Yes.
this application, Inspector such and such, I of the case submitted that all the LS accused persons, hypothesized such and such have been interrogated in the present case, hence prayed sent to judicial custody. This is on the first day, madam.
Item number. Take it.
Except for 409, who have been eligible for in 60 days.
Hmm.
Except for 409,
Hmm.
we otherwise would have been eligible in 60 days for bail also.
What's the second, any,
My lord.
you have approached the trial court?
I approached, my lord, but the trial court went on leave.
Hmm.
That's why we withdrew and, my lord, we filed it here. In any case, 439, my lord, your lordship can.
Who is the admission? They have admitted.
Yes, my lord.
Where it is?
In there is 160 statement.
Hmm?
My lord, I have flagged it, my lord.
161.
Yes, my lord. I have flagged it.
It's of Changlang district.
Yes.
And DDSC office.
Yes,
Yes, ma'am.
All of them.
all of them. LDC, UDC, KCR, and BEO.
This is item 13 is.
Item 13 is Likkem Tangha.
Huh?
Applicant is different. The accused person will be Likkem Tangha.
Okay.
Likkem L-I double K-E-M. 58-year-old lady.
Hmm. You paid 13 lakhs
13 lakhs. I'm not aware of that.
for UDC.
But ultimately, the man who made the most money is at the top, not me. In any case, that money has gone down the drain now, if it is a fact. Because the beneficiaries are terminated now.
And your daughter also has resigned.
Yes, ma'am.
Terminated.
No, he is resigned. When this
Oh,
Fiesco
I'm not aware of that. The only thing I'm submitting, my lord. On the first day itself, the IO said they have been interrogated and they are not required, my lord. What is the purpose of keeping them in there? That is my only humble submission. This, my lord, will go on trial, my lord. Resign.
So,
Well, No objection.
Heard Mr. Deepang learned counsel to the petition applicant. Also heard Mr. Opada learned special PP SIC. This is an application of section 439 of CRPC, 1973. For grant of post-arrest bail to the accused person, Srimati Likkem Tanga.
Yes,
Is page, the item 13,
page 2.
who has been arrested by SIC on 09/02/2024. In connection with SIC within bracket vigilance BIG, bracket close, PH case number 03 of 2024. Under section 120, bracket capital B, bracket close, 409, 468, 471 IPC, read with section 13 within bracket 2, bracket close, PC Act 1988. And presently detained and presently in jail since her arrest. The case set up by the prosecution is that after series of complaints filed by the district-based students union and community-based organization before the deputy commissioner, Changlang district, regarding illegal appointments, public regulation of trained graduate teacher, primary teachers, upper division clerk, lower division clerk, and multitasking staff in the Department of Education in Changlang district. The deputy commissioner Changlang conducted an inquiry and came to the conclusion that 5 trained graduate teachers, 29 primary teachers, 8 UDC, 13 LDC, and 22 multitasking staff were illegally appointed in the Department of Education in Changlang district. After preparation of report and the dossiers, Deputy Commissioner has same was submitted to the Chief Secretary, Government of Arunachal Pradesh, and the matter was announced to SIC Vigilance for investigation, and the case was registered as SIC. Accordingly, the case was registered as SIC within Vigilance BIG, very close, case number 03/2024 under section so and so, the same section. The SIC Business has taken up the investigation. Full stop. On the FR reveals that the name of the petitioner, name of the daughter of the accused person hearing was appointed as UDC, which is reflected in serial number 27. And the brother of the alleged accused person was appointed as MTS in the MTS and appeared as serial number 38. Though however, the name of the present accused person is not reflected in the FIR. The SIC thereafter issued summons to the accused person on several occasions for investigation and interrogation of the alleged accused person in connection with the aforesaid case. When you were arrested finally?
My lord,
Where you were arrested finally?
9th of February.
Finally, the alleged accused person was arrested on 09/02/2024. And on production, she was remanded to the judicial custody for 14 days. But since then, the alleged accused person is in judicial custody. Next bit. Mr. Deepangi, the principal applicant, submits that the alleged accused person is serving as UDC cum cashier
Yes.
in the Department of Education in the Changlang district. However, her name has not been, she has not been named in the FIR. And the and she has been arrested only on suspicion, only because her relatives have been appointed as UDC and MTS. Having submitted that, Mr. Deepangi, without reverting to any other grounds, submits that the accused person was arrested on 09/02/2024 and was remanded to directly remanded to police, the judicial custody. And there is no prayer by the SIC for her custody. Mr. Moreover, she has given her statements before the investigating officer and is cooperating. Mr. Therefore, since it's been nearly 41 days,
42 days. my lord.
42 days by now, come on. The custodial detention is not required in the present case. Therefore, he prays for grant of post arrest bail to the accused person as no custodial interrogation is required, as evident from the remand order of the trial court. Listen. That's your only submission. No custodial interrogation
yes.
is required.
Because here the
You have
IO
already
itself
given
is-
your statements.
Yes. Even before custody also I have given statement.
Mr. Opada Leonard, special PP, SIC. Referring to the case diary, fairly submits that there is no ground to object the prayer of the accused person for release on post-arrest bail, in as much as she has admitted under section 161 statements that she had paid rupees 15 lakhs. Should I record that? Will it be prejudice to you?
That may not be recorded, my lord. Ultimately, they will have to face trial, man.
161. I said 161. 161 is not. But otherwise, since he has no objection in view of that, we have to. I said
Yes.
as per 161
Anyway, my
statements,
lord, hardly.
she has admitted that she has paid. She has paid the amount. We will not mention the amount which was sought by the higher authority for appointment of her daughter as UDC. That's all. We'll say 161 statement.
Yes.
Mr. Next pair.
Hello.
The due consideration has been extended to the learned counsel for the parties and also where is the case diary, Mr. Next pair. On consideration of the case diary, it reveals that the petitioner has made a statement that
The
she
accused.
has, the accused has made a statement under section 161 of CRPC that she has paid an amount which was sought by the higher authority for appointment of her daughter as UDC. It is also seen that the petitioner was arrested on 09/02/2024 and was remanded to judicial custody without there being any prayer by the SIC for her custodial interrogation. Needed as it may, the 42 days has been elapsed by now, and in the facts and circumstances of the present case, discordance of the view that no custodial detention is required, as the custodial interrogation is not required. Next, in view of the above, of the considered that the accused, namely so and so, huh? What Tanga?
Likkem Tang,
Likkem Tanga.
L-I-K-E-M.
Srimati Likkem
Srimati.
Tanga is entitled to be released on post-release bail. List of next para accordingly. It is provided that the accused person, namely so and so, still be released on bail on furnishing a bail bond of rupees
20,000.
20,000 with one surety of life amount on the following conditions. You give all those
Conditions, my lord.
What else? What should be conditions?
He should cooperate whenever required by the missing agency. And he will not
All
provide
those
evidence.
You get that. That long one. We'll correct it.
Item number
The bail application stains allowed and disposed of.
Obliged. Item number 12, accused person's name would be Lomkang Rekhung.
Same section.
Same, exactly, exact fact same. Lomkang Rekhung. But when
The facts will be little different.
a little different
you
about
find out
the
from there,
yes that
12, what is the statement?
Lomkang Rekhung. Lomkang Rekhung. L-O-M-K-N.
Lomkang
Rekhung.
Yes. LDC. Huh?
Is LDC.
LDC.
Earlier one is UDC. Is item 12 LDC. Daughter is MTS. Huh? It's okay, you get the facts differently. Well, I'll get
Yes.
the facts.
I will give the name of the accused person. Next one, item 14, Chaipot Techai, C-H-A-I-P-O-T Techai. Working as BEO, Block Education Officer, under bracket TGT. Then item 15, Lomwang, L-A-M-U-A-N-G, Mosang, M-O-S-S-A-N-G. UDC.
My lord, Lombang Mosang, I have not played it, my lord. The first one, my lord. The first flag one before the Lombang.
UDC. UDC.
Before
Lombang.
that page. That's it. Lombang Mosang.
Then
My lord.
then
15 is done.
15
12,
is
14, 15.
Mosang. Okay. The facts will be the statement and all this will be little different. We check it out. All right. Post name
Ma.
and the statement in the CD that will be different. It's not all money trial, huh? Money, money trade.
13 years first.
Oh, I check
Likem tang.
statement. What's it stated? Right?
Obligement, Hariam.
Malal, CD will be retained, Malal.
Huh?
CD will be retained by.
It's in original, original?
Yes,
Original copy.
Yes, Malal.
Let me, we'll have to tell you what is here.
Malal.
After this, I mean, this thing, after this signing, you will get.
Obliged.
You just recorded CDB. Case diary be returned in all cases. After signing only, you'll have to.
Malal.
Arrested on the same day. Same. Okay. Hmm.
Was your department of work?
Nah, I got it.
Yes.
Do
Do you have the CD?
Yes.
Yes, sir.
Am I audible?
Yes, yes.
But I'm not hearing her lordship properly. Maybe there is something in the system.
Should you hear me or I should hear you? Should I or?
This is the
should you?
petitioner before lordship.
Yes.
Is an applicant.
Can I take up? Can I take up?
From Halo? He is
Just-
now holding the post.
Just
of
wait. Just wait,
Deputy
sir.
Director of-
Just wait, sir.
My lord.
Can I take? Can
My
I
lord?
take up this matter?
My lord, this is what I was thinking. That is why I mentioned the name of the person. If your lordship has difficulty, lordship may post it on some other date, my lord.
We'll see on 27. We'll see it on 27.
27.
Hello.
27th, I may have some difficulty. Let us have it on 8. Can I have it on 8th, my lord? 8th
8th of April.
April.
8th of April.
My lord.
08.
08.
What do you say?
No problem.
May not be appropriate for me.
Right, probably. But I think as per the roster, 8. We need to see the roster.
On the prayer of Mr. D. Majumdar, learned Senior Counsel, list this matter on 08/04/2024.
Lordship
You-
may mention, if your lordship is not taking up, lordship may mention that not by your lordship, so that next time same thing doesn't happen.
20. In that case, I cannot fix it again. If I record that, I cannot fix the matter.
My lord.
We'll see on 8.
My
let
lord,
us see.
my lord, my lord.
You retain the CD.
My lord.
Interim order to continue.
My apologies, my lord. My
Yes.
lord, item number 17 and 18 are out of the same PS case and out of the same file, my lord. Therefore, my lord, I am praying for taken up together to these two items, my lord.
Hmm.
So I am appearing item number 18, my lord.
Hmm.
So, my lord,
Basically, we are here for the innocent plea. So, my lord, in that
What plea?
extent, innocent plea, my lord.
Innocent plea.
My lord, in that extent, my lord, the subsequent development took place after the filing of this, my lord, anticipatory bail. So, my lord, there was an agreement between the parties.
Huh?
Agreement between the parties.
Don't jump to that. What is the matter? Just tell
My
us.
lord. First of all, my lord, this is the case when the FIR was registered on 31st January 2024 against the unknown person. So, accordingly, my lord, on the suspicion, my lord, that we have been, my lord, this petitioner in item number 17 and 18, we have been, my lord, declared wanted from the police, my lord. And accordingly, my lord, till then, my lord, we have no idea about whether the case has been registered or not. We come to know when the police has summoned us under section 41A of 28 January 2024, my lord. Then only, my lord, we come to know that the case has been registered against us. So, my lord, accordingly, thereby, my lord, we have confirmed that the case is registered under 307, which is, my lord, non-bailable offense. Therefore, my lord, we could not appear before the, my lord, concerned police on the ground that this is 307. If we happen to appear before this, my lord, definitely we will be arrested.
Yes.
Therefore, we are here before the lordship to protect us from the, my lord, physical arrest. And now, my lord, subsequent development, what I am trying to report this honorable court, my lord, on the last occasion also, my lord, we have brought. So today we are coming with the additional affidavit. Here, my lord, on confirmation, here the accused, the main accused who involved in the crime has
Proceed, please.
has clarified that I was not involved. My lord, the Hentogamno and this Shoni Ratan. And accordingly, my lord, agreement was executed. Wherein, my lord, this agreement revealed that whatever the injury caused to the victim, that the person involved, which is not before this honorable court, one Nunu Partin, he has, my lord, consented to bear all the medical expenditure, whatever, my lord, the cost to the victim, my lord. And accordingly, my lord, some amount has been, my lord, compensated. Now, one thing, my lord, this, my lord, agreement is, my lord, initiated by the Gurukha Student Union. Here, my lord, Shantipur PS case is, my lord, lying between the two states, state of the Arunachal Pradesh and the Assam. Therefore, my lord, amicably, these students, not that these students are pressing, but the only amicable solution that these students are also involved, initiated from dear, my lord, so that, my lord, the matter can be amicably settled. And accordingly, now both the parties has come to the settle that the victim is, my lord, compensated. And at the same time, so far, my lord, my case is concerned, the petitioner in these two cases are not involved in the case, my lord. Thereafter, my lord, one thing, my lord, I am as a petitioner in item number 18, Hentogam, my lord. I am recently married and recently, my lord, appointed. I am doing in the, my lord, WC Kalasi in the Department of the Power, my lord. And I have been, my lord, engaged in the election duty. And the lordship will find in my affidavit, additional affidavit, my lord.
Yes.
Wherein my name is reflected in the serial number 35, Hento Gamno, male classic.
35,
35, serial number 35,
additional affidavit.
my lord. In page number 12, wherein my lord, the election duty has been, my lord, entrusted.
You are a government servant.
My lord, I am government servant. And one thing, my lord, I am still under probation. Recently, I am yet to complete 2 years in the, my lord, government servant after jobless. There,
What is
therefore,
your working is?
I am working as my lord, WC, my lord.
Huh?
WC Kalasi. Additional.
Which petitioner?
My lord petitioner Hento Gamno.
Your Lordship, I have not received this additional affidavit that they are pointing out in item number 18. Your Lordship. Neither.
So, my lord, in view of the facts, my lord, even if the investigation is continued for the sex that the case has been registered under non-bailable section, but till then, my lord, we may be protected from the physical arrest, my lord. Because, my lord, by the agreement, my lord, it is agreement wherein, my lord, this is clearly revealed that the person involved in the crime has clarified that he was alone who had involved in that case, my lord. And for that, he has already bear the medical expenses to the victim. So, my lord, in under such circumstances, my lord, we may be protected the anticipatory bail, my lord. And we are praying for that, my lord.
Where's the order of the learned session judge?
My lord, order of the learned session judge is appear in, my lord, page number 17 to 18. In my petition, my lord, 17 to 18. Eighteen is the, my lord, operating portion or operating part in page number 18. Should I, my lord, read out the operating portion in page number 18?
Is it appropriate once the concurrent jurisdiction has been
Yes, yes, Your Lordship.
exercised,
Yes, Your Lordship.
then
Any bail application moved before the trial court, Your Lordship. Once that is rejected, Your Lordship, on the same section, since this court have the concurrent jurisdiction, even the same ground can be taken, Your Lordship, and it would not be considered as subsequent bail application.
so
Yes, Your Lordship. I have also, on the last occasion, Your Lordship has retained a CD, Your Lordship. Now,
Hmm.
now if I may take your lordship to the statement of the victim, your lordship, which is at page number 25.
25.
Yes.
Hmm. Yes.
Now your lordship will come to page number 12, your lord. Since your lordship is well aware that he was left all naked and injured in the jungle, your lordship. His mobile phone and all the money were also taken, your lordship. This was a case of zero evidence, your lordship. Subsequently, what happened? The investigation officer traced the mobile number, your lordship, since the mobile was also taken. At page number 12, your lordship will see the note, your lordship.
Hmm.
One of the accused has called his friend, and that's when the number and the trace of the accused persons were revealed, your lordship.
Hmm.
Now, if your lordship will come to page number 13, the second paragraph, your lordship, starts with now different.
Yes.
That's when the name of these two accused were also revealed, your lordship. Subsequently, on 28th of February, 41A notice was issued to the accused person to be present before the IO for interrogation, your lordship.
Hmm.
And the lookout notice of bounty of 20,000 was also posted through social media, your lordship. Instead of coming to the police station to cooperate with the investigation, if your lordship will come to page number 19. In connivance with all the student unions, your lordship,
Hmm.
they tried to settle the matter outside the court.
Hmm.
Also, the admitted submission today made, your lordship, that there was a pressure group who were given the charge to settle the matters, your lordship.
Yes.
Now there are clear prima facie evidence against them, your lordship, in the CD. Also, your lordship, the subsequent submission that an additional affidavit is being filed, bringing into a court's notice about the agreement. Now, can an agreement, mere agreement, be a condition for granting of bail, your lordship? Your lordship, also to be seen that if that agreement was forcefully done or was voluntarily done, your lordship. Also taking into consideration the section 307, attempt to murder, your lordship. Your lordship will also come to the agreement, your lordship, additional agreement, your lordship. Your lordship is well aware, even in quashing agreement, your lordship. Normally, agreement is not a document where a person just make an agreement saying that he did not do it, your lordship. Agreement in terms of quashing or any in terms of criminal offenses, your lordship. Agreement is done between two parties. If both the parties, if accused is involved and he either pay for the expenses, your lordship, or seek for apology, your lordship. Now, if both of the accusers, they deny in the agreement and they have left the entire accusation on one of their accused, your lordship. Now, even under section 482, your lordship, I have just the judgment. This is just a reiteration of Lakshmi Narayan, your lordship. This is just a, if I may just read the paragraph, Your Lordship.
You read it.
Yes, Your Lordship. Taking into consideration at paragraph 15.4, down below, Your Lordship will see page number 14. Reference was made to Lakshmi Narayan, where it says even 307 and Arms Act are serious and heinous offense, Your Lordship, and therefore the court should not under 482 quash the case, Your Lordship. And in the last paragraph, the court has made an observation that 307 falls in the category of heinous and serious offenses, Your Lordship. And therefore, under 482, the court cannot be nipped in bud with the while exercising the power under 482. Now, if that is the condition, even under 482, that such compromise under this section, Your Lordship, cannot be quashed, Your Lordship. In this bail matter, Your Lordship, will see bail matter only prima facie case has to be seen. Subsequent, if there was any agreement, Your Lordship, if that agreement was voluntarily made, and if those sections that they have been alleged, Your Lordship, is of simple nature or not, that has to be considered, Your Lordship.
Apart from this statement, any medical report?
No, Your Lordship.
Injury report?
No, Your Lordship. Your Lordship will see attempt to murder. Your Lordship will see he was left in the jungle, Your Lordship. The whole night he was there, Your Lordship. He was recovered only in the next morning by a passerby, Your Lordship.
Badly assaulted, but can it be said that it's an attempt to murder?
Yes, Your Lordship. If there the more intention, Your Lordship will see if a person is beaten up, Your Lordship.
No, see,
He is not taken to the hospital, Your
they
Lordship.
have asked for a money.
Yes.
He didn't give. Victim
He did not
So
give.
He was assaulted.
He was taken to the highway. Your Lordship will see if he was assaulted, Your Lordship. If any person, Your Lordship, knows that such assault has been done, Your Lordship, and subsequently realize that this might lead into a condition that he might die, Your Lordship. Some of victims are also taken to the hospital, Your Lordship.
That may not be an attempt to murder.
You never know, Your Lordship. If I may then, in that case, allow to bring into record the MLC, Your Lordship. My only,
Say MLC.
My lord, if
You
court
bring
is-
it.
my lord, if
my
court
only
intend
objection is,
to
Your Lordship, will
say-
also see that without even appearing before the IO and cooperating with the investigation, Your Lordship, they have put upon the pressure of a student union, creating disturbance between two states, Your Lordship.
But then
And-
in the way, it erupts because of this, it was some sense of the disturbances erupted between these two things. So in a way, compromise is okay. May not be, you may be correct that it cannot be a ground for granting bail. But I'd like to see the
my lord.
medical
So-
injury report.
So, my lord, my prayer would be if my lord, this court intend to see the medical report, my lord, then in such situation, my lord, the interim bail may be granted, my lord. Since my lord, so far, my lord, since the case is supposed to adjourn, otherwise, my lord, I am supposed to reply what my sister has placed before this.
no, Your
Well,
Lordship.
grant the interim
I'll-
and allow direct them to
I'll-
appear before the.
My only concern is, Your Lordship, here is that there have been, from the very day one, Your Lordship, this is, Your Lordship has rightly pointed out, if there is any amicable settlement, Your Lordship, it's
Why not?
not taking into
why not
consideration
taking
the,
it on record, they may have.
yes,
filed it.
Your Lordship.
We'll consider it.
But
and
the only thing is,
We
even
may not, rely on that.
41A notice was also given. They were asked to appear in the month of February, Your Lordship.
It's
They had
okay.
not been cooperating and therefore wanted poster was
Produce
also.
the medical injury report, next date, will grant them interim.
In that case, Your Lordship, interim may,
He
a
said,
very short date may be given
you have.
on Monday, Your Lordship. On Monday,
What
at
about
least.
the medical expenses? Did you,
My lord,
huh?
that my lord, the one person who involved has beer, my lord.
Has borne the expenses?
Only
medical
one of the
expenses.
accused.
One,
But
Oh.
he is not before this.
and my lord,
No.
exactly, not before this, no,
You are still stuck to that you are not involved.
my lord,
Huh?
my lord.
Heard Mr. O. Modi, learned counsel.
C. Modi, my lord.
C. Modi, learned counsel for the petition. In both the cases,
my lord.
you are
7th.
okay. Separate order, we'll first in one order.
If I may, only on interim, your lordship, may fix this matter immediately on 26, your lordship. I'll bring the MLC report, your lordship, and also updated CD, your lordship.
We'll ask them to appear tomorrow. Can you appear tomorrow?
My lord, if interim granted, my lord. The moment interim granted, my lord.
If it is not, you will not.
Be-
You are absconding.
No, my lord, since my lord,
Not
we are
Mr.
ready,
So-and-so,
we are
no.
ready to cooperate.
And also in item 12, item
17.
17. You are 18.
My lord.
This matter on 26,
My lord, can it be on
03, 20.
28 instead of 26? I will be out of station, my lord, on 26.
Okay,
28.
28.
on that day, the learned additional PP to place the
Updated CD along with MLC report.
updated CD and MLC.
Deeply obliged.
Till then, my lord, interim be granted, my lord. Because
You cannot appear tomorrow, so
my lord, if my lord court directed, right from tomorrow, but today itself, my lord. What who have my lord and we are quite apprehensive that my lord we may be arrested. We are ready to cooperate the my lord investigation. So we are eager to appear before the police. But the question is that why, my lord, we are here to protect from dishonorable court, so that at least we may not be so that we may not be in the custodial detention, my lord.
May your
We
lordship.
want, my lord, this should be investigation should be proper and this should be, my lord, speedy. But the question is under 307, my
you
lord.
are also government 7. No,
No.
then we will grant him not to you.
So, because I'm also not involved in this case.
We don't know. It's a matter of trial.
Yes, Lordship.
And you have not appeared before the IO.
I'm ready to cooperate with the investigation. If Lordship granted I'm appear before the IO.
Your lordship, if I may.
You
check
are
on-
from
I'm from GRS. Same.
same area. Considering that in his case, considering that the applicant accused is serving as
Serving as Kalashi, my lord.
Kalashi
W. Kalashi in the power department.
WC Kalashi in the Department of Power and has been engaged in the ensuing
Lok Sabha election.
Lok Sabha and Assembly election. Pending production of the updated case diary and MLC
MLC, your lordship.
by the London Additional Public Prosecutor in the interim. It is provided that the applicant accused, namely so and so, in this case, in the event of arrest, shall be released on bail on furnishing a bail bond of rupees 15,000 and 102 lakh a month, so and so, on the following conditions. The accused shall appear before the IO on
28.
Huh? Not 28.
you appear
My lord, my lord.
Tomorrow, your lordship.
tomorrow. Can you?
My lord, the moment I receive the order, day after tomorrow, man.
Saturday you can appear
Yes, sir.
on 23rd.
23rd.
23rd, 03/0/2024 and all other conditions. In each case, heard Mr. So-and-so, same order, but then considering that the applicant so-and-so is a permanent resident of the local jurisdiction of the local,
My Your Lordship, if I may just for a moment, Your Lordship, why I'm harping.
we'll
on-
see on 28.
Yes, my only that 307
This
is
court is of the view that there is no case of 1307.
if he was
Prima
beaten,
facie.
he was beaten in the head and he was made
Yeah.
unconscious, Your
I
Lordship, and he was left in the jungle, Your Lordship. That will obviously amount
We'll
to
consider
attempt.
finally on 28.
My only submission with regard to 41A was that
Yeah.
this is 307, that is imprisonment for more than 10 years, Your Lordship. Arnesh Kumar says if 41A should be given in the case below 7 to 7 years. Since they were not cooperating, we have also made an effort under 41A also giving them notice to cooperate, Your Lordship. They did not even come, Your Lordship. And therefore, my objection was with regard to the objection of bail, Your Lordship. Because they have not been cooperating, and instead of that, they have made a pressure, made up with a pressure group and came to such kind of settlement, Your Lordship, which is completely disrupting the investigation, Your Lordship.
Okay. I'll record that the
Yes.
additional PP has vehemently opposed the prayer for interim so and so. Then having considered so and so, then considering that the accused applicant accused is a permanent resident of the local jurisdiction of what? Jia
It's-
police station.
No, Your Lordship, this is
A permanent
Dibang-
resident of
Lord Dibang Valley.
which place?
Dia
Dia
village
village.
under Rowing.
Here
Within
village,
the local jurisdiction.
POPS
of
rowing.
Police station, rowing. Come on. In the end, you say, furnishing bail bond of so and so. Same. This is the matter on 28th. Since he will be appearing tomorrow, let us fix on 2nd of April,
No, Your Lordship, on 28th of,
28th.
because if only MLC and updated, their statement will also be there, Your Lordship.
Okay.
Your objection is recorded.
Yes, Your Lordship.
Then what is this? Instead of it, that timing. Oh, 6. Item number 4. Item 4.
Yes, Lordship.
Ah.
Form. Lordship, this is 430th application, Lordship.
Offense?
Offense, Lordship, this 354. That,
What is 354?
yes, 354 is criminal assault to outrage the modesty of a woman. Lordship, here I already appeared on 18/1/24 before the IO. And I have recorded my statement. Now only because of elections are coming, and I think my apprehension is that they are forcing the IO to arrest me.
Why election? Why it is related to election?
Because we belong from this 2 different political party. Otherwise, after 3 or 4 months, why IO will come to my house to look for me? There's no other thing. It should be charge sheeted by this time, Lordship, actually.
Third, Mr. Newbury, learned counsel for the applicant. This is an application, the first time
This is the first time, Your Lordship.
application. Will go to the case diary.
Yes, Your Lordship.
Then grant interim.
Yes, yes.
Section 438 of CFPC, Common Section 4. Grant of privilege of prayers bill. In connection with cybercrime PS Itanagar case number 07/2024 under section 292 and 354. Redo it. Section 67 of Information Technology Act 2000. Call for the case diary. MS TJ Lana edition case on behalf of the state. Pending production of case diary, so it's in the interim, in the event of arrest. No, in the interim, it is provided that in the event of arrest, so and so, namely so and so, shall be released on interim bail on furnishing a bail bond of rupees 20,000.
Lordship.
one security of like amount so and so, following conditions.
Lordship, may fix this matter on 1st of April.
It's this matter of 0102, 04/2022.
Deep-
My lord, this is an appeal by the state, my lord.
Arbitration appeal.
Arbitration appeal, because there was an interim order passed before the arbitration proceedings, my lord, has started, my lord. And in that interim order, which has culminated into a final order, the execution of a second tender has been stayed, my lord. My lord, in brief, my lord, what happened? The respondent contractor, he was awarded through an NIT, awarded the work for construction of a mini secretariat building. He was awarded that work. During the construction of the work, he started claiming that there has been some price escalation. He has done some additional work. And then thereafter, he started making claims for additional funds. Accordingly, what the engineers of the department, they started that a revised estimate should be made. But that was turned down. Turned down that no, cost escalation, it was a turnkey project, whatever cost escalation that cannot be done, my lord. The revised estimate has to be of a total different work, my lord. Now, they are not handing over the building to us, and thereafter they filed the money suit claiming compensation, my lord, monetary compensation. That was also one suit was technically defective. It was withdrawn. Second, also it was filed, but no interim was granted. And then the Section 9 application was made under Section 9 arbitration application was made. Then Section 9, in that Section 9 arbitration application, the execution of the subsequent tender has been stalled, my lord. Tender was already floated, the lowest bidder selected, and agreement drawn, my lord. But because of the interim order, which has culminated into a final order, the work cannot be executed, and the proceeding of arbitration proceeding has also not begun, my lord. Now, my lord, there is a power under of Section 9 to pass interim order by the district court before the arbitration proceeding or during that arbitration proceeding or even after the execution of the arbitral award, before the execution of the arbitral award. My lord will kindly see first, my lord, before the impugned judgment, at page 87, my lord. This is the sanction order, my lord. Page 87, annexure 2, my lord.
Yes.
This is the sanction order. The governor of Arunachal Pradesh is pleased to accord administrative approval and expenditure sanction in principle not exceeding 25 crores only for construction of mini secretariat building at Daporija in Upper Subansiri district, phase 1, through executive engineer so and so, so and so. In serial number 2, it says the project should be completed with the original scope and specification, and no revision of estimate will be entertained. Whatever fund, whatever scope of work is there, it has to be completed within this fund of 25. This is a phase 1. Now, accordingly, tender notice was issued, my lord, at page 88. And approximate value of the work was 25 crores, my lord. This was on turnkey basis, my lord. Now, the contractor, he being the lowest bidder, my lord, his bid was accepted, my lord, at page 91, my lord.
91.
Yes, my lord. His bid was accepted for a contract price of rupees 24 crores, 24.25 crores, my lord, is hereby accepted. My lord. And he was directed to furnish the performance security of 1.2 crores by 9/8/2019 or 2016. It should be by within 28 days, my lord. Valid up to now, my lord. There were subsequent reminders for furnishing, depositing the performance security, my lord. Ultimately, my lord, after depositing the security deposit, my lord, for performance security, agreement was drawn, my lord, at page 94, my lord, on 7/11/2016. Agreement is also for an amount direct 24 crores 25 lakhs, my lord. At page 94, my lord. Within this, he has to finish the work. My lord.
Yes.
Now, at page 99, annexure, my lord, this page 99, he starts claiming that there has been some cost escalation whatsoever, my lord, and he makes a request to the executive engineer for preparing a revised estimate. My lord will see he has requested for, I'll not bother your lordship with all. He has asked that there has been some cost escalation.
Yes.
Transportation cost has increased, all such, my lord. Then what happened, my lord? The field officers, they initially sent as per the request of the contractor, they sent a revised estimate at page 102 to the chief engineer. They wanted the work to be continued by the contractor. The field engineers, they said, while adding some new works, but few new works, but mostly the cost to make up the cost escalations, something like. This was forwarded at page 102, my lord. This was submitted, my lord, signed by the assistant engineer, executive engineer, superintendent engineer. Now when this was submitted, there was an objection raised from the local MLA, saying that this cannot be allowed to be done. There has to be further infrastructures for the functioning of that mini secretariat. Further infrastructure, just the building alone will not do. Boundary walls, gates, landscaping, many things have to be done. Therefore, this this request was made by the local MLA. If my lord sees at page 113, I'll just read out the relevant portion.
Is there any relevance?
No, my lord, just because they are alleging that all things are happening because of the local MLA. Local MLA has done the right thing. When the contractor has completed his work,
It's a separate work.
Separate
Addition
work.
work, but then separate work.
separate phase 2
The
work.
first tender work is over.
First tender one
What
is
is
over.
their claim?
Their claim is that they need compensation for this additional works and cost escalation.
That is different issue.
Different issue.
That cannot be followed. That will be examined.
Yes,
What the court, learned trial court has said.
Learned trial court there was a prayer before the learned trial court that the subsequent work should also be awarded to me, because
What about their prayer for this thing, the additional work and all those revised estimate, whatever?
That it has to be by the arbitral tribunal.
It will
But-
go to arbitration.
Yes.
I mean, the expert, review expert.
Review expert.
What do we call it?
Review
As per the
expert,
agreement.
Is initially it should be before the review expert. If the review expert gives any decision,
Then arbitration.
arbitration.
Yes.
But there was a prayer before the trial court that the very work should be awarded to me.
So you are agreed by that. Arbitration part you are
No,
not.
I'm not agreed by that. What the learned
Yes, sir.
trial court has said, everything make the measurement, but
What is this his jurisdiction?
My lord, jurisdiction, the district judge has, my lord, under section 9. But before that, if I may.
Why is it in section 9? Section 9 application.
Section 9 application, my lord. Section 9 for interim measures of protection. My lord,
No,
here,
see, if the works are separate,
my lord,
page 1, you are allowed, you have been, you have got the tender,
my
you
lord,
have constructed, whatever differences, you are entitled under that page 1,
my lord,
the first tender.
my lord,
You will entitled.
my lord.
That will be subject matter of arbitration or review expert, whatever.
Yes.
But the second tender, why it can be stayed?
My lord, there lies the problem.
Hmm.
If
There
my
are-
lord comes to the NIT,
Hmm.
the NIT given is construction of the district of the mini secretariat.
Yes.
My lord, 2 NITs were floated, one for 0, one for Dapo region. Here we are concerned with 0, with Dapo region.
Hmm.
My lord, exactly similar sanction order, my lord, similar tender. In my case, I have been allowed to work. The second revision, the additional works and all, in 0, it
It
is
was of 25 crore.
similar.
So your tender was 24. point
25
something.
crore. 0 was a bit lesser, around 20.
No, yours is
25. 25.
Your the rate you have quoted is 24.5.
My lord,
It
my lord,
has to be under that only.
my lord, my lord,
Within that only you can claim.
my lord.
Is the second tender part of that?
Exactly, my lord. That is the thing. My lord, if my lord comes to the revised estimate, which my learned friend pointed out, before that, my lord, all the documents are not before lordship. The annexures of
No,
the.
you just only show
Yes.
me that
Yes, my lord.
whether this the second tender, the amount is a part of within the 24 crore.
My lord may come to page 106, the revised estimate,
Yes.
which was prepared prior to intervention by the MLA. 106, my lord.
There's so many.
My lord will see name of scheme, construction of district secretariat at Dapo region. Estimated cost now comes to 50 crore. Then my lord may come to serial number 5,
90,
page 106, my lord.
106. Information sheet of scheme
Yes.
proposal.
Yes, my lord.
Huh.
Name of scheme, it's the same word. Then estimated cost, here is 50 crores. Now my lord may come to serial number 5. Physical progress up to date, 80% of the 50 crores.
Huh?
Yes, my lord. I have completed almost 80% of the entire revised estimate. That is why this revised estimate was.
50 crore?
Yes, my lord, 50 crore. At serial number 2, my lord. This is the revised estimate because they asked me to do additional works. Revised estimate is 50 crore. Is estimated cost, my lord, at serial number 2. It's 50 crores. 5,000 lakh. Out
What?
of that,
500.
5,000, my lord.
Okay.
50 crores.
Construction district.
Then, my lord,
At the in upper.
serial number 5. Physical progress up to date, 80%. I was given to understand, my lord, that I would be allowed to.
No, this is which, it's a revised estimate.
Yes, my lord.
which has been turned down.
Turned down by the chief engineer after the local MLA's UO note. This is all on the records. 50 crores work, my lord, I have completed 80%. Now, my lord may come to the next page.
No. How can you work for 50 crore?
My
When
lord,
your tender was of
tender,
24
because
crore.
additional works were allotted. There was no order, but I was asked to. My lord, it is there.
That was the order.
My lord,
See, your tender is of 24
my lord,
and 25 crore. Let us assume that
my
the
lord,
amount put to tender is 25.
my lord.
How can you work for 50 crore?
My lord may come to next.
Under apprehension.
My lord may come to the next page.
Yes.
I'll read, my lord, because this gives a history. The second para of under history, my lord, The original sanction to this project was accorded in the year 2014, file number so-and-so, dated so-and-so. Only for the main building component only, which is 50% of the total project cost of 50 crore approved by memo number so-and-so 2015. The building portion, G+3 RCC structure having plinth area so-and-so, subsequently awarded on tender for a total consideration of 24 crore 25 lakh, only to Messrs. Kurumkume Enterprises, Itanagar, wide LOA number so-and-so, dated 15/2/2016, with formal agreement signed on 17/11/2016. Contractors claim regarding additional transportation costs of cement, steel, and hardware items from Guwahati and Itanagar, Bandar to Daporijo, via letter number 4/10/2016. Over the above approved BOQ rates was assured to be considered later in exigency and after detailed analysis of all contractual issues. Project commencement already delayed by almost 2.5 years, 31 months from sanction date, no longer could be dragged on in view of time and cost overruns in public interest. Technical sanction for complying with guidelines prescribed in CPW Manual 2014, thereafter accorded retrospectively, wide number so-and-so, dated 8/1/2020, on the basis of design and BOQ submitted by the contractor. The project launched in 2017-18 after signing of the formal agreement is now in the finishing stage, as can be seen from the photographs attached in the report. But for suspension of work restrictions due to subsequent first and second wave of pandemic COVID-19 in 2 phases, the dates are given, the project would have been physically completed earlier. Then, my lord, the project status.
No, the present contract is the NIT is for 25 crore.
My lord, that is the problem, my lord. The first one, though it was for 25 crores, I was asked to do other works on an assurance that they will be considered later. I did. Now, my lord, the revised estimate was floated just like in zero. In zero, the contractor has been allowed to continue the work.
It's okay. It's up to them.
My lord.
But as a matter of right, you cannot.
My lord, the second.
You show us that you have been allowed to do all this additional work for the worth another.
My lord,
like the tender which they have plotted.
My lord,
see, for example, in the second tender,
my lord,
the works which you have been allowed to do as an additional work,
they are part.
If it is a part of that
it is
component.
Yes, my lord.
Have you constructed boundary wall?
Boundary wall. Some part we have, but some part
that you have to show.
My lord. My lord may come to page 96.
How you have been allowed? See, you will have to confine to within your within your contract agreement.
My lord may come.
Tender was plotted for 25 crore.
My lord.
You are given whatever you have done.
My lord.
Within that, if you don't get, you have a right.
My lord.
But so far as the second tender of another 25 crore, you cannot. You are entitled to participate.
My lord, the components are almost the same. Of the second, of the so-called.
Same or almost the same?
Almost the same. My lord.
We don't know.
Some component. My lord may come to.
That may be a subject matter of
the arbitration. Yes, my lord. My lord may see what the district judges order.
Yes.
My lord may see what the district judges.
They are only agreed by the stay of the tender.
My lord.
The second tender. Will stay that.
My lord may come to the district judges.
You have allotted awarded the work.
We have already entered into agreement, but because of the interim order, execution has been stalled.
So
my lord may.
It was properly published.
Properly
How many participants?
All properly published.
Have you participated?
No.
They also came to know. That's why they filed suits to stay that NIT itself.
My lord may come to the impugned order, which is under appeal, page 29.
29.
What is the order passed?
Yes.
Second para, my lord.
In this connection.
In this connection, it appears on records that there is undisputed fact that there are points of arbitration on the basis of pleadings of the parties. Hence, the matter is arbitrable and the applicant has already sought for arbitration as per the contract agreement. Further, it is also noted that it is alleged in the plaint that some of the works already included in the NIT dated 6/8/2015 has been included in the NIT dated 9/10/23 on perusal of the documents by the applicant. Hence, some of the works in the subsequent NIT dated 9/10/23 are disputed issues. However, the matter could only be decided by arbitration tribunal and any relief for it could be considered by the tribunal under section 17 of the Act, and this court has limited role to play under section 9 of the Act to grant interim relief to protect the applicant on satisfaction of the test of existence of dispute to be addressed by the tribunal. The matter is arbitrable and balance of convenience is in favor of the applicant. Considering the fact and circumstances of the case, it is observed that the tests are satisfied except that the new work under phase 2. Therefore, I am of the opinion that since there is a provision to refer before the dispute review expert, the issue of inclusion of the work of the first tender in the subsequent tender may be referred to the dispute review expert by the parties. Further, as agreed by the parties, the joint measurement shall be conducted at site within a period of 1 month from the date of passing of this order. My lord, further, as agreed by the parties. The joint measurement shall be conducted at site within a period of 1 month from the date of passing of this order. Till then, the interim order dated 4/12/23 shall be continued till final measurement is done and proper handling and taking over after clearance of bill to the applicant, if any, on joint measurement. My lord, he has not stayed the second tender. What he has done, my lord, is joint. Otherwise, my lord, let us visualize the other situation. What happens if this order is interfered with? There will be no joint measurement. What work have I done? What will be left for the
That's
arbitrator?
right. Yes, he's saying that the second tender has not been
No, my lord.
stayed.
Till then, the interim order.
Yes.
What is the interim order?
Interim order is the execution of the second tender.
My lord, till the joint measurement.
My lord, not
Why
only,
don't you have a joint measurement?
we are ready to go for the,
We'll say,
but
clarify that.
here it says, my lord,
He himself is saying that there is no stay.
yes. Then,
Till
But then we'll say you go for as directed by the.
my lord, the offending part is that we are ready for the joint measurement, but pay, whether he's entitled to payment.
Handing and taking over after clearance of
Of
bill
bill.
to the applicant. if
That
any-
means the final order. We are ready for the joint measurement, whether he is
This
entitled.
includes the arbitration,
Yes.
the arbitrable issues are including the payment.
Payment.
So how can this be?
My
Yes,
lord,
my lord.
payment of the admitted amount, maybe that was
Obviously.
intended by the district.
We have said we have,
We'll say,
My-
you avoid by the, you comply with this, the order of district judge, to have a joint measurement,
and handing and taking.
and handing and taking.
My lord, after the
and
joint
whe-
measurement, because my lord,
Ah.
if the handing and taking over occurs before that, the other contractor will claim that he has done the work.
No, my lord.
So therefore, my lord, until and unless the joint measurement is done,
And moreover, you have agreed.
yes,
I
my lord.
agreed to the aspect of joint measurement, I still agree. But there is an order, after the joint measurement, you have to make payment.
My lord,
And
payment,
that-
that law
that-
should make clarification.
That is the offending part. But that has to be decided by the arbitration, arbitral tribunal, my lord. Now, we
But
are saying
after
that we
the
have
joint-
made the entire payment.
My lord,
Our claim is that
why-
he has not used. We have made the entire payment.
my lord,
By this,
sir.
what has to be arbitrated, that has been decided, my lord. We are,
No,
After-
you could have done your part when you have agreed the joint agreement. I mean, joint measure.
joint measurement, we are ready, they are not ready. Give us a date for joint measurement, and whatever payment is required, if they are entitled, that is a matter for arbitration. But after the joint measurement, the handing and taking over should be done. We have been requesting for handing and taking over, my lord.
My lord, we have also sent a letter on 6th of March, my lord,
We have,
for joint measure. This is, my
we-
lord, I have the copy, my lord. This is the original.
the
acknowledgement.
offending part is, they want the payment also. As per that,
This is
payment
my,
also.
my acknowledged copy.
my lord will kindly see, my lord.
My lord, so if he is aggrieved by the payment part, my lord, payment of the admitted amount, they can pay. That law should make
We are
sense.
not admitting anything. We have,
Of the amount on joint measurement, which he would.
no,
which
no,
you
we
might
have,
agree.
our claim is that we have already paid, made the full payment.
Before joint measurement, how can that be done, my lord?
My lord, that is why,
Before measurement, how can we say that we have made the full payment?
my lord, if my lord, I may be allowed.
We'll do one thing. Notice has been issued.
My lord, this is the first time. The
No.
other day,
We'll issue notice.
my lord.
In the meantime, by way of interim, we'll direct you to go for joint measurement
Yes. Yes,
within certain date.
on a fixed date.
You agree fixed date?
Yes, my lord.
Make a
And,
fixed date?
and thereafter, handing taking over.
Then handing and taking over?
Yes.
And
After
if is there is any undue due admitted due, you
Yes,
should also
yes, my lord.
make the payment.
That is a part of our claim, my lord.
No, after the measurement.
Yes, my lord.
After the measurement, suppose according to joint measurement, if there is something, some liabilities which admittedly the state has to pay, then you pay. If not, if there is a dispute, suppose after the measurement, if admitted no, undisputed amount is there, you have to pay. If disputed, it will go to
Yes,
the,
my lord.
any dispute, it will go to the arbitration
My lord.
Yes, my lord.
as directed.
Yes, my lord.
And the order of this, the 4/12/2023 still be.
My lord,
Okay.
till the joint measurement.
Huh?
Because, my lord, before the joint measurement, my lord, if the other contractor comes and takes over, my lord, there will be disputes once again, my lord. So let the joint measurement be done. After that, my lord, the handing and taking over after joint measurement, as per the contract, my lord. My lord, they have not annexed the contract, though it was part of the record there.
Or
And
we'll say immediately after the joint measurement,
handing and
the
taking over.
authorities are
Yes.
proceed with the second tender.
Yes, my lord.
Yes, ma'am.
Yes, my lord.
That,
Otherwise, the
that
arbitration will
payment
become
part,
infraction.
payment part will be decided, my lord, by the arbitration.
No, suppose after the
Oh,
measurement.
yes, my lord, will say if it is admitted. My claim is that we have already paid.
It's
Question of-
okay. Then that will be a dispute.
Yes, my lord. Only if
Suppose after the measurement, in the event you found that these are admitted amount, make a payment.
Yes.
If not,
Yes.
any disputed amount,
That will
it will
be-
go to the, it
Yes,
will
my
be
lord.
subject matter of arbitration. We'll
Ma-
clarify that.
Yes, my lord. My lord, may I also clarify?
You
After
are
the,
only agreed by the continuation of the interim order.
yes, my lord.
of
Handing and taking also
4/12/27.
after the joint measurement, handing taking should also be done there.
What is your prayer?
My lord, prayer is for setting aside
Of what?
the impugn order, my lord, and to
Where is
allow
your-
the contractor,
Where is your prayer?
Their prayer, my lord, is
my lord, at page,
sorry, before
this is an appeal, my lord. Was the impugn order,
page 18, my lord.
page 18,
Okay. Looking at this.
Quashment of the order.
and in the interim to allow carry out the work.
We'll
Second
give
phase.
you 15 days. Within 15 days, you make it, then thereafter, immediately thereafter, you proceed with the
Work. Yes, ma'am.
second transaction.
Yes, ma'am.
Huh?
Yes. Within
All
15
right.
Yes, madam.
Where is the prayer you have made?
At page 18, my lord.
What is it?
Prayer is to,
It's an appeal.
yes, madam.
Appeal under 37.
Okay. Heard Mr. N. Ratan, London, Additional Advocate General for the appellant, and also heard Mr. P.D. Nair, London Council for Respondent number 1. Respondent number 1 and 2.
1 and 2, my lord.
Then you said appellants, huh? This is an appeal. No, this appeal under section 37 of the Arbitration and Conciliation Act, 1996 is preferred by the state of Arunachal Pradesh. Assailing the order dated 04/03/2024 passed by the District Judge Pasighat Basar Misarbitration case number 01 of 2023. particularly with regards to the continuation of the interim order dated 04/2023 passed by the passed in the above this case till the final measurement is done and proper handling and taking over after clearance of bill to the applicant, if any, on joint measurement. Mr. That's your only, yes. Otherwise, you have agreed, it's a consent order,
Yes,
so
my
far
lord.
as joint order is
The
concerned.
payment part.
Joint measurement.
And for,
Well, issue notice on, should we record the facts?
Why not?
Issue just,
Issue
issue notice returnable by 4 weeks. Since Mr. P. Diner, learned counsel for the respondents, accept notice on behalf of.
or minor can, if,
Respond number 1 and 2.
minor can dispose it directly.
Huh?
Yes, ma'am.
My lord, all the records are not before lordship. That's because,
I have craved leave
It's
because it
okay,
is-
I think it's almost amounting to grant your relief,
it's almost the final
Yes.
relief.
final relief.
yes, ma'am.
It's okay,
It's okay.
we'll issue notice.
Oh.
Or in that case, we'll dispose it on 27.
Minor, then, not,
Issue
because
notice,
we
yeah.
want the work,
Issue notice, yeah.
but
But in any case, we'll be giving minimum 15 days. Yes. To both of.
My-
Uh,
As one factor, my lord, would be the elections, which that's why I asked my
Uh,
learned
well,
king, my
that-
lord, whether they would be able to do it.
appears on behalf of respondent 1 and 2, no formal notice this week. I will extra copies be furnished to the learned consequent respondents. Hard on the interim period. Come on. Considering that. No. What is that interim order?
My lord, 4-3,
Hmm.
page 22 on.
It is noticed that the learned district judge, Pasigar, has
page 30, madam.
was the following orders. Page 30. Therefore, I am so and so and so and so. Come, next one. On perusal of the order, the reference to the dispute review expert as well as thereafter the arbitration as well as the joint measurement to be conducted by the parties has been agreed by the parties. Mr. However, the agreed portion of the order, whereby it is provided that till the final measurement is done and proper handling and taking over after clearance of bill to the applicant on joint measurement is to continue, the interim order is to, interim order that is 04/12/2020 is to continue. The state is agreed. Considering that the issue of the issue involved in this present matter relates to public works, particularly construction of
District, mini secretary.
ministry at Dapurija, Khammam. This court is of the view that the works, the public works should not be stalled due to, should not be installed. Mr. It is seen that the tender was plotted, a tender was issued for the, it's a second page.
Yes, second phase.
Tender for works in second phase was issued, huh?
Yes, ma'am.
On
9/10/20.
9/10/2023. Thereafter, the process has been completed by entering into an agreement with the successful bidder by the state. Come on. It is appropriate to provide that the
Tender has been
state,
accepted.
both the parties, the appellant, appellant authorities of the state and the respondents shall conduct a joint measurement within a period of 15 days from today.
Yes.
Within a period of 15 days from today. And if any amount due to the petitioner, any admitted amount
Admitted by the.
admitted
appellant.
amount due to the petitioner, the respondents is due, I mean, if
By
any,
the
after the joint measurement, if any amount is, admitted amount is due to the respondents, same shall be.
My lord may say
Paid.
any amount which may be admitted by the department, by the appellant.
May be admitted by the, no, if you
which-
don't admit, it should not be admitted amount, right?
Yes, my lord.
Just because if he claims, because after the joint measurement,
Yes, my lord.
how much amount would be? Other you will,
My lord,
both of,
then-
if you both of agree,
Yes,
if the both parties agree that is, this is the amount, then it will be a admitted amount. If not, suppose if he claims that this amount I am entitled, if you, I mean, dispute it, it should not be admitted
my
amount.
lord may also then clarify if there is a dispute on the
No, that's what I'm saying. If any amount found to be admitted is due, same shall be released. And if any, if otherwise disputed, same shall be referred to, same shall be the subject matter of the arbitration.
yes, ma'am.
Review, that's a dispute review expert, thereafter the arbitration. This term. After after the joint measurement of the after joint measurement by the parties within 15 days, the appellant state shall proceed with the tender
Execution of the tender.
and proceed with the execution of the tender. That is 09/10/2023. That's all.
Yes, ma'am.
One of the handing over after joint measurement.
Huh?
Handing over after joint measurement. That may be better.
Measurement. And handing, what is this?
Handing over and taking over
Handing and taking over
of the site
of the site after the measurement.
after measurement. After measurement.
15 days you finish it?
Yes, ma'am.
I think it's basically amount to granting the.
Yes, my lord. My lord, Lordship had dictated, my lord, that the contract has been signed, my lord. But
It's-
in the annexure,
It is
they have
ex-
annexed, my lord.
accepted
the
and-
acceptance, letter of acceptance is there, but whether the
it's a-
contract is signed.
not
is not.
contract,
My
it
lord,
will be-
yes, ma'am.
No,
Page
I
47.
accepted or notice. this-
My lord, acceptance, they have asked to deposit the performance.
It's
Yeah.
page
247.
240. This is the
240.
last thing,
Yes, ma'am.
stage.
Yes.
So contract most
Because
probably.
242. Page 242.
245.
245.
47, man.
Check it,
After-
245. Page 245.
47, man.
47. So there's no agreement.
There's no idea.
Agreement, I
LOA
think
is-
so we have
LOA.
made.
LOA.
we have made.
Acceptance.
we have
Letter of
made,
acceptance has been issued. Anyway, that's not a disputed
Yes,
now.
my lord, those things.
Whatever is there.
I think there was an statement.
We'll go by the
In
document.
any case, that is not-
Anyway,
that is
the
not disputed.
agreement, no agreement, we have
my
allowed you to proceed.
my
That's
my
all.
my
That is what you want.
Yes, my lord.
After journalism.
After you-
After 15, the
Yes, my lord.
15 days, works.
My lord.
Problem.
Deeply obliged.
List after 4 weeks. Yes.
Number 19.
19 is over. Already adjourned.
Somebody might have died.
Yes. I think on behalf of Mr.
Winter.
B. Picha, I think the mention has been made. No,
I
you were
was
not
sitting-
consulted, I mean,
Oh, there.
no consent was taken from you.
It's okay. Because
Okay.
obliged.
Yes. Item 20. What is to be done?
Yes,
today?
Lord. I'm for the petitioner here.
You're supposed to take press steps,
Service, yes, sir.
huh?
We took steps on 29 to 2024.
Yes.
29 February.
Taken the steps.
Yes, sir.
Then in that case, heard Mr.
Bidulam.
for petitioner.
Yes, sir.
Therefore,
Your Honor, I am for respondent number 1.
Mr. Swain for responding. Next matter, office note dated 20/03/2024 reflects that service report is still awaited. List after 3 weeks.
Yes. Your Lordship, there is an interim also that may be
Interim order
continued.
passed earlier shall continue.
Obliged.
Yes,
Lordship, this matter may be adjourned because main counsel is out of session.
on the prayer of Mr. Swain shall learn council for the list this matter after 4 weeks.
Your lordship, meanwhile, updated TCR may be called for, your lordship.
The updated TCR
TCR, your lordship.
be called for.
Deeply obliged.
Yes, sir. What is to be done today?
My lord,
Steps for service to affidavit of human. You have not filed affidavit.
My lord, I
Have you
will be filing, my lord.
Okay.
On the further 3 weeks, now within 3 weeks, we'll file, my lord.
No, you have steps.
Private respondents there.
Respond number 4.
Yes.
You have not taken.
No.
But Mr. The steps.
Step I have taken, Lordship.
No, it reflects something different. Respondent number 4. Who is respondent number 4?
It's a private respondent, my lord.
Who is lying? You are a registry. And Mr. D was a learned counsel for the petitioner. You take a press steps? Take press steps because it reflects that you have not taken steps. 20 day for yesterday, office note. Office note reflects that. Office note dated 20/03/24 reflects that the petitioner has not taken steps for service of notice upon respond number 4. Mr. So-and-so, the budget learning principal is permitted to take steps for service of notice of for respond number 4 within 2 days, 3 days.
Within 3 days.
3 days. Thereafter, process be issued. Mr. T. Tagore, learned Standing Council
Yes, madam.
for Health
Education, madam.
Education Department is granted 3 weeks time to file affidavit in opposition. This after 3 weeks.
Deeply. All right.
You are mentioning it,
Your Honor, senior counsel is engaged in
other
the-
court.
Yes, in other court.
What is to be done? Mr.
It won't be
Mr.
possible for
Mr.
today.
Pertin,
Yes,
T. Pertin,
M.
M.
Pertin,
Pertin.
yes.
Then
It won't be possible today, so Your Honor, it may be fixed.
what happened?
My lord.
This 2017 matter,
My lord.
what happened?
My lord, this case, my lord, although the petitioner, they were appointed recruiter through a regular process, my lord. There was a competition and everything was done, but
The issue
after-
is about certificates only.
yes, ma'am, only.
Whether recognized or not recognized.
Yes, my lord, that part is there. Now they are raising that what they are raising, my lord, the issue is, my lord, they have submitted a document, my lord, which has been duly verified by the scrutiny committee, my lord. Now the impugned termination order that has been issued, my lord, although the personal hearing, my lord, only the personal hearing, that part is clear, my lord. Personal hearing, personal opportunity was not there. We have communicated through deputy commissioner, and thereafter, my lord, on the basis of that only this was done. So only the issue remains, my lord.
You found prima facie that these documents which they have submitted is not recognized, or it's a fake document?
My lord, that
Fake
part,
document or not recognized?
my lord, that part, my lord, only we could verify through.
Now, how,
Next, my lord.
that's why, how can
Yes.
you, without giving them a notice?
That is, my lord, that
How
is the
can you
only.
just on the basis of your
That's-
presumption,
that
on
is
the
the
basis
only-
of the net? I'm not saying that you cannot rely.
Yeah, that is.
You may rely, but opportunities should be given.
Yes, right. Yes, my lord. That is the only issue, my lord. The
What is your prayer
opportunity-
today?
Your Honor,
We thought of allowing your writ petition, it's 2017 matter, what is to be done?
I am instructed to
Only.
take
Adjourn
the
the matter
adjournment, yes.
For
Your
this
Honor.
thing, the matter,
Yes.
on 27. Can we take it up?
My lord, can be. Otherwise,
Or first
only.
week, first week? It's a 2017 matter. On the prayer of learned counsel for the MS. Your name, please?
If I'm given, if I'm may being allowed, then it may be allowed, Your Honor.
No, we'll have to hear that for that. MS so-and-so, learned counsel for the learned counsel appearing on behalf of Mr. M. Pertin, learned senior counsel. Praise for listing the matter after 2 weeks.
Yes, Your Honor.
We'll make it 1 week, after 1 week. As the, then it's, as her, then senior counsel is engaged in court number 2. Mr. The prayer of the then consultative petitioner is allowed, and the matter been listed for hearing in the first week of April 2024. Mr. T. Tagore, then senior counsel, then standing counsel for education,
Health, my lord, is the health, my lord.
health, as well as yes. P. Sangeeta, London State Council are present. Are present. You have filed the affidavit there also.
My lord, here we have filed affidavit.
There's nothing more to be clarified.
My lord, that is only personal hearing part.
We'll dispose it of
My lord.
first week. 2017 matter. Huh? This
Deeply
recording. Huh? This matter. Can I take up this matter?
Pardon,
There was in connected matters, I think I have appeared.
Yeah, I
When
think
was-
so, your lordship. I was not remembering, so your lordship.
I think this was
Yeah,
compensation.
yes,
and
yes,
all.
your lordship.
Not this.
You
not
you
like
may
this
recuse
matter, but
yourself,
this was
lordship, if
in
you think
earlier
so.
round, but connected. to
Yes,
the
you're
same issue.
very right, your lordship. I in fact mentioned that to my learned friend also.
I just got,
Yeah,
but I tried to find out was there any orders where my name is reflected.
I couldn't find,
it,
I couldn't find it in the final orders, your lordship, but
but then
as per your memory, I also share the same.
yes, yes, I appeared.
So your
once in
lordship,
related-
you may post it for,
We'll say list this matter before any other appropriate bench without me. Huh?
much obliged. But I regret one thing, your lordship. The first time I appear before you as the judge and I'm not able to argue. That will be a regret I'll have.
I would love to hear you.
Yeah, but I hope it's another matter.
It would have been my privilege also.
Yeah. No,
It's not
mine too,
privilege.
your lordship. Mine
Yes.
too, your lordship.
Anyway, next time.
Much obliged.
Who appears for what? Whom?
My lord, myself for the appellant.
What is there?
27, is it 27?
Rightly rejected.
No, your honor, actually, there is.
You have to establish negligence. 166.
Yes, your honor, page number, your honor.
Are you
27.
ready?
Page number 27.
Are you ready?
No, no, the counsel in this case is Mr. Toktem Time. He's not present today.
You are appearing on.
I'm not appearing. I'm not going to be able to
You
submit.
are
on his
making a
behalf.
mention
Yes, ma'am.
on his behalf.
Yes, ma'am.
Actually, there's nothing.
No, your honor, see the page number 27.
I've seen it. It's okay. Not Mr.
BR Das.
B.R. Das.
Yes.
Learned counsel for the appellant, huh?
Yes, your honor.
Appellant. MS.
Your Honor, I have also been informed that steps on respondents have not been taken, although they are submitting that it's
You
been
are for
taken.
respondent number 1.
Yes, Your Honor.
You take fresh steps.
No, your
respondent
honor,
number 2.
step is already over.
When?
Yes, your honor. On the last orders, there is
Let us
paper
see.
statement for OP number 1 and 2.
Where it is?
Steps was taken in the IA, Your Honor, apparently, but in the appeal, they have not taken steps. And the
Right.
IA has already
This
been.
court has
disposed of.
already allowed. Notice has been already served.
Where it is?
My lord, it was.
Appellant, the notice of response to have been served through the paper publication. Have you filed the affidavit?
Yes, your honor. Yes, my lord.
No, it's all served.
I have
Paper
submitted-
publication.
Yes, my lord.
Then MS
T.Y. Bhutia,
T.Y. Bhutia, learned counsel appearing on behalf of
T. Time.
T-Time, learned counsel for the respondent number 1. Pressed for listing the matter after a week or 2. After 2
After
weeks.
3 weeks, my lord.
After 3 weeks.
3 weeks.
Praise the Lord. List this matter after 3 weeks. List this matter after 3 weeks.
Yes.
But you have to see that.
Yes, my lord. Yes, my lord.
Yeah, please.
Hmm.
My lord, the issue is very simple, my lord, in this case. It's only issue whether, my lord, second FIR is maintainable. Because law is very clear, my lord, that second FIR is not maintainable. Here in case what happened, my lord, that an accident occurred, my lord, during which my Scorpio dashed one Maruti car and one bike, my lord. So immediately, my lord, these people, they bashed me, they physically assaulted me, and therefore I filed the FIR, my lord. And on the same day of the alleged incident, my lord, this one of the owner of the, my lord, vehicle, car, he lodged the FIR, my lord. And that FIR was lodged on 22/3/2023. Then very interesting, my lord. Thereafter, my lord, after 1 month, my lord, that the second impugn FIR, my lord, this was lodged on 18/4/2023 in respect of the, my lord, same incident, my lord. And thereafter, my lord, the consequential charge sheet has been filed on the basis of second FIR. The law is very clear, my lord, because FIR.
What happened to first FIR?
a first FIR trial is going on.
Okay.
So for that one too, my lord, I have to face that one. So for the second FIR, my lord, on the basis of the same incident, my lord, it is not maintainable. That's why I'm seeking quashing of this second FIR.
What is the charge sheet? Do you
Yeah.
have the idea about the first FIR?
Just both in the first FIR also charge sheet has been filed. Now trial is going on. I am facing
Same material.
same thing,
Same
my lord.
material in the charge
My
sheet.
lord, my lord, my lord. Basically, same means, my lord, here.
Or it's a little improved version.
My lord, yes, the second FIR is the improved version. So, because, my lord, one accident, my lord, one incident, in which, my lord, my Scorpio hit both the car and bike. So, information was lost saying that incident took place. And during which the vehicle, the car and the bike was hit. Now, my lord, when the FIR was lost, investigation taken, then, my lord, charge sheet is filed. Now, where is the question of, my lord, in the same incident, second FIR lodging by this, I'll just take to my lord's page number 16 and 17, my lord. Is the, now second FIR, page number 17, my lord. This is the second FIR, my lord. My lord, I just read 3 lines that will make it clear. I am writing this letter to file a report of a car accident that occurred on 22 March 2080 at around Sri Genom Pertin, an employee of State Bank of Hapoli, in an inebriated condition, hit my parked Alto car bearing registration number so and so from behind and totally smashed it near soul. So he is the owner of the, my lord, this Alto car 800. My lord, now let's come to the first FIR, my lord. My lord will find at page number 79, my lord. My lord. 81. Now, my lord, this FIR was lodged by the owner of the motorcycle, my lord, on the same day, my lord, 22, my lord. With due respect and humble submission, I would like to state I parked my Bajaj Pulsar so and so bearing register in the roadside at Pengu near Harigate for urination on so and so. At about 2 AM, I parked my motorcycle in front of an Alto car bearing registration number so and so belong to Sri Tapi Tasan. Another motorcycle belonged to was also parked near my motor. Suddenly, a Scorpio car bearing so and so coming from hit the Alto car. My lord, first hit the Alto car and my motorcycle, causing huge damage to Alto car and my motorcycle. This information was already lost. Then investigation, then my lord, charge sheet is in file. Now, after 1 month, my lord, how, my lord, it is not legally permissible, my lord, under the law, my lord. I have citations over the TT and any case. This has been made very clear, my lord. And this honorable court also passed in one case, my lord, that second FIR is not maintainable and cost, my lord.
It's not in all the cases. There's a distinction.
My lord, there can be distinction, my lord. But here is the case, my lord. It's the same incident, my lord.
What is the phraseology? The same incident, but narrating something, narrating some story, narrating the different, narrating the story having different materials. That is permissible.
My lord, so far, my lord, the law is saying, my lord, that regarding the, because FIR is what, my lord, basically.
It's not bar per se. It can be second FIR.
Second FIR is bar, my lord. It cannot be, my lord.
No, it's not per se. It's not per se bar.
My lord, second FIR, my lord.
Narrating different.
No, it's, my lord, yes, my lord, counter.
Not counter.
My lord, so far, here, law is there, here, my lord, that so far, my lord, counter case is there, it is permissible.
Not counter. Second FIR, not in all the cases.
My lord.
The phraseology is something like the Supreme Court says,
my lord,
not by this court. May be maintainable with narrating the story with a material, different materials, something like that. After that, What is the cases you have relied on?
Because my lord, this T.T. Anthony case, there has been relied on Arnab Ranjan Goswami case of 2020 also. T.T. Anthony, my lord, I will first rely on. Is number 15, para 15, 20. My lord, para 25 and 27, my lord.
Yes. 27.
25 and 27, my lord.
25, I have read it. 20 is just Yes.
My lord, our order passed by this honorable court, relying on T.T. Anthony and this Arnab Goswami case, my lord. The second FIR has been caused in this case also, my lord. My lord, it is something like this, my lord.
This is a case where the respondent has agreed to the proposal amalgamation of the both the FIRs.
My lord. Otherwise, my lord,
And Arnab
my lord,
Goswami,
it's not, my lord.
Now, Arnab Goswami also a case of different.
My lord, here, no, my lord. Here the issue is like that. There
These
also,
two
my lord,
FIRs being, your two FIRs by filed by different persons.
my lord, it is something like that, my lord.
The
Suppose,
honor of the Alto and the honor of the
my lord, it is something like that.
motorcycle.
If I shoot, my lord, with a single bullet, if 2 persons is died, my lord, then it is not something, my lord, that because 2% died, that's why 2 case will be registered against me. That is not permissible under the law, my lord. This is what exactly it is done in my case, my lord. And in this case also, my lord, what happened? When the court says that second FIR is not maintainable, then court says that second case cannot be proceeded. Okay, that second material that should be taken together with the first case, my lord. So this is the problem because, my lord, FIR is something, my lord, the first information.
Is the proceedings going differently? Or it's been taken together?
No, differently. One has been state, my lord.
Two trials.
This proceeding has
Two
been
trials.
This has been state, my lord.
Trial has been going differently, your lord.
It should not be.
One on this FIR and another on the other FIR.
Can it be?
No, my lord. There can be no
Therefore-
second case,
How
my
can
lord.
there be
There-
two
therefore-
two
there-
report and
Yes.
two church incident
Absolutely.
from same incident?
Yes, your lord.
But so far as these cases are, the Anup Goswami and all facts are different.
My lord, basic principle is
Basic principle,
Yes,
normally
ma'am.
there cannot be two.
there cannot be in respect of the
Second
same
FIR.
incident, my lord.
Ah,
But
second
that
FIR.
says that in case of larger conspiracy,
I have come across, there is some other case laws.
my lord, some
That's why I'm saying
exceptions are there.
Per se, it is not
No,
barred as such.
my lord, each fact has to be seen, my lord. When there is a question of conspiracy, larger conspiracy, then in some exception that is there. But basically, my lord, the first information is the, my lord, basis on the same information, my lord, second, because subsequent information will be a statement under 161, my lord. So, my lord,
So what do you want?
my lord,
Trial should be
quashing of the
taken together.
No, my lord. No, my lord. Quashing of the because, my lord, 2 cases cannot be, my lord. I cannot be, my lord. This will be violation of my fundamental rights, subjecting me to, my lord, for single offense, subjecting me to face the trial to trial, my lord, for the single offense, my lord. That will be otherwise, my lord, violating of my fundamental right, my lord. That won't be as per the procedure of law, my lord. So, my lord, what I want, my lord, because in this first FIR, my lord, everything is covered, my lord.
What do you say?
Yes, the lordship, to be very fair, lordship has rightly pointed out that arising of the same fact and same circumstances, your lordship, there cannot be a two trial, your lordship. However, your lordship will see that the second FIR very clearly says the reason for the delay of the FIR, your lordship. In the first FIR, however, there is a mention that it was not that he had first hit the Alto, and then subsequently while running away, had hit the motorcycle, your lordship. As per my understanding, this is the same arising out of
First FIR.
same
First FIR.
first FIR, your lordship.
Second
That
FIR.
he hit the side of the Alto and my motorcycle. As per my understanding, your lordship, it flows from the same circumstances and same facts, your lordship. The second FIR, if your lordship will see, has also mentioned that there was his Alto was parked and it was hit, your lordship. The same has been mentioned in the first FIR too, your lordship.
But difference is, I think first one is it there in a abbreviated condition? First FIR. Is there mention of that?
Your lordship.
First FIR.
Yes, your lordship.
In abbreviated condition. Second FIR is there.
Second
My lord,
Is it
that-
same?
my lord, incident is same, my
No,
lord.
that's- You tell us. Second FIR, there's a mention on in abbreviated condition. Second, first FIR, is there anything like that?
in an abbreviated.
Second FIR in abbreviated mention.
In abbreviated condition. Second FIR.
Yes.
The only that word, particular word.
Is
your
there
lordship.
anything in that thing?
No, your lordship.
How do he know that after one, how he came to know that? This is by same person?
No.
No,
It is, my lord, first.
One is by Alto and
One is by the bike.
Second one is by the bike, my lord. After 1 month, my lord.
So what do you say?
Your lordship, with regard to your lordship query as in abbreviated, your lordship.
No, I'm just wanted to know.
Oh.
It's an improved version, that's what I'm saying.
As per my understanding, your lordship, since the first FIR is very clear as to even the heating of.
Because he might have thought the accident, it could be,
Exactly.
if it is normal thing, it could happen.
Yes, your
What's the, the problem there?
Yes, your lordship.
It could happen to anyone, just hit the, then part,
Yes, yes.
whatever. And after 1 month, he thought, no, you will have to put this condition.
Yes.
My on the very first day of when
To
this
make it an offense.
my objection on the very first day of this when this matter came up, your lordship, was only the difference bringing into record the status of this second FIR, first FIR, your lordship. Why? Because my only contention was that if it was after hitting the alto, he runs and then hit the bike, that would have been a changes of circumstances, your lordship. That would break the flow, your lordship. However, in this case, it was very clearly, even the FIR says that alto and the bike. And for my, as per my understanding, your lordship, it's a same facts arising out of same circumstances, your lordship.
That's why initially I indicated whether it's a improved version.
Your lordship.
So most probably by a second FIR, by putting that condition, because the law is, it is not permissible to have a drink and drunk and
Yes,
drive.
yes, to bring under this.
Drink and drive.
279 IPC, my lord.
So,
I'll leave it to your lordship discretion. As far as my understanding, your lordship, it's flowing out.
why discretion? When you
I completely, in that fact, I completely agree with.
court, frankly, when lives into this court, where we would not like to apply the discretion. When there is a contest, then we get what is the exact to, the root of the matter.
In that
When
case,
there is a contest.
Yes, yes.
in that case, your lordship, I completely agree to what the Honorable Apex Court has clearly mentioned when a second FIR is not permissible, your lordship. Also, I have seen the judgment placed by of this Honorable Court, your lordship. The only difference there was that it was not charge sheeted.
Yes.
That was not charge sheeted, and these cases has been charge sheeted, your lordship. And both the trials are parallelly going, your lordship. Same date of incident by the same vehicle, your lordship. However, there is no even differences in the time, your lordship, and even on the occurrence of the place. And therefore, my understanding is it's the offense has occurred from the same fact and circumstances, your lordship.
Yes.
My lord, to be very fair enough, my lord. My lord, it seems it appears from this older records that the incident, this impugn FIR should be the first FIR actually. What has happened is that they have some settlement in the police station, outside the police station. The difficulty arises when the first was the private respondent here. His car was hit by this the accused person. Now, on the verbal assurance of that the elder sister of this,
it's okay. That is
yes,
factually thing.
So,
whatever you argue on the law.
Your Honor, my lord,
is it permissible?
My lord,
according to you.
My lord, to be very fair, my lord, it is
not permissible.
Yeah, not permissible. And when
then matter ends there.
Yes, my lord.
Criminal petition allowed? Dispose of. Okay.
All right.
Anything else?
No.
With charge sheet, my lord. Along with FIR charge sheet.
If it is not maintainable on this, we'll definitely watch that all right. FIR and the consequences charge sheet and then the proceedings.
Yeah, man.
Yes.
Man, I want to mention one criminal petition.
When?
Tomorrow.
Tomorrow not possible.
My lord, since
tomorrow we are leaving at 10, where this court is rising at 11:15. Next 25, 26. All right.
Much obliged.
Even if it is allowed, we will not be able to take up.
Much obliged.